I would like to say I'm here on special appearance. No, I think I have some rights here. That I'm a living soul. I am not the straw man of the all caps. Okay.
We'll get to that in a moment.
So I am waiving
the time.
I am not waiving any of my rights.
Ma'am.
What statutes or what law or what are you saying here are the charges? Because this does not match. Sorry, I have cotton mouth so bad.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you? Excuse me. This. Sure. Thank you, sir. If you took some dollars. Such an interesting out.
All right, good morning. We are on the record in the 89th District Court for the County of Sheboygan. We're conducting the physical hearing upstairs in the circuit courtroom. It's being clerked by the 89th District Court staff down in that courtroom. And we're here in the case of In re Beth Bridgman on a contempt matter. It was filed in an underlying criminal case 23-0868SD. We are providing public access both in the courtroom, in the circuit courtroom, and also online. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Paige Miller on behalf of the people.
Attorney Eric Villanova appearing as a arraignment attorney on behalf of Beth Bridgman.
All right, good morning,
Although I will represent myself.
Yes,
Okay.
we'll get to that.
I would like to say I'm here on special appearance. No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
Ma'am, you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that in a moment.
So
but
I am waiving
the time.
I am not waiving any of my rights.
Ma'am. Okay. Thank you.
Ms. Bridgman, you're free to stand or sit, whichever you're more comfortable with.
I don't know how I would pull the chair up, so thank you.
Well, then, if you want, you want to sit there, I have no problem. Okay. All right. Okay. All right, well, Ms. Bridgman, you're here for an arraignment on 2 allegations of contempt, so I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, 2023, which alleges that you are in criminal contempt of court for the unauthorized practice of law and for preventing the defendant, Seth Flores, from meeting with the Michigan Indigent Defense Commission attorney prior to his arraignment. We scheduled that for a show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it says your offer to contract is not accepted. And then you did not appear at that show cause hearing. So therefore I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So
Failing to appear for order to show cause on Wednesday, December 20th, 2023 at 11 a.m. for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the 2 contempt citations pending against you. You have the right to have a hearing on both of those allegations where your contempt would need to be proven beyond a reasonable doubt. You have the right to present evidence in your own defense and to cross-examine and challenge any of the evidence presented against you. You have the right to an attorney. If you qualified and requested, you have the right to an attorney appointed at public expense. The MIDC provides an attorney for your arraignment today, just as a courtesy as required by a statute.
MIDC?
Michigan Indigent Defense Commission.
No. You also, of course, have the right to represent yourself. Do you know, well, first, do you comprehend the penalties? Oh, I'm sorry, I didn't tell you. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail. and or a fine of $7,500 or both. That's the fine, that's the maximum penalty for both of the contempt citations. Ms. Bridgman, do you comprehend the rights that you have that I outlined for you and the maximum penalties I outlined for you?
I think that I would like to wait. I have a call into the state trooper that your office or the prosecutor's office called to investigate something with me. And I was on the phone with her and told her I had received the show cause, and she said, he can't serve a show cause. I shot over a copy of it. He can't serve a show cause because you're not under bond. This is from the State Attorney General's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court. And I know that this is not what was on the original document in its entirety. So you have amped up the charges based on the fact that I failed to appear, but I believed she was going to let you know. She was collecting information from me for you.
Ma'am,
Okay, now,
just understand what the judge asked you regarding those two charges.
Did you just understand that I think there's a bigger overriding issue?
But
Thank you.
Wait, hang on.
Thank
I'm
you.
not going to have this.
I'm going to fire him, actually, so thank you very much, because I will represent myself.
Okay. So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present any.
No, because you already,
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between
Thank you.
you and Ms. Bridges.
I guess I just like to, state that
well, I think we need to back it up.
she's pleading not guilty to both of those, and that she would like to request a hearing, that she would like to represent herself at that future
Okay.
hearing.
No, but all of my rights were strongly impinged upon for even when I never failed to appear.
Okay. We're going to have a hearing where you.
She was working, okay,
Okay, you're going to get your
Mr.
hearing.
Villanueva,
No,
I'm
this
directing you to
is-
stop
thank you.
arguing with Ms. Bridges.
Okay,
I mean, it's a pretty serious thing to have to spend the night in jail, to be brought in handcuffs and everything else, when I was not being belligerent in that regard. She told me that it was not an authorized show cause.
All right, if she told you that, she didn't have the authority to do so. But anyway, that's for the later hearing. So
Well, she
today's
was
purpose is
investigating.
to-
Okay.
Today's purpose is to advise you of the two contempt citations. So do you comprehend the maximum penalty that those could carry and the rights that you have that I outlined for you?
Now, can I ask, what statutes or what law or what are you saying here are the charges? Because this does not match, sorry, I have cotton mouth so bad. This does not match what the previous document was that you sent to me. And I have a picture of it on my phone, but my phone's not with me. Okay?
I've
It
told
does
you-
not say,
I've told you the charges. I don't have to answer further questions about that from you. Do you understand the rights that I listed for you and the penalties?
why have they changed,
I'm
Judge
not
Beck?
answering that question.
Can the prosecutor?
No,
Why?
I need an answer to my question. Do you understand that? So you said you want to represent yourself, right? You wish to represent yourself and not have an attorney represent you?
Yes, I
Okay.
do.
If you want to do that, I must establish that you know what the penalties are and what your rights are. And I have to establish that you're not going to be disruptive to the court. If you refuse,
So are
if
those,
you refuse, then I'm going to appoint
not
an attorney for
refusing.
you. Okay, then I would appoint an attorney for you and you'd not be able to represent yourself.
I know, I listened to that with Trevor's case.
All right, so I'm asking you, and you saw what.
How can I
Ms. Bridgman, so I first have to make sure you know what the maximum penalties are and what your rights are. Do you not?
Those maximal penalties are based on the charges, and I'm wondering how you arrived at a change in the charges.
I'm not answering that question. You know that you could face up to 93 days in jail and or a $7,500 fine. You understand that?
Up to that, okay, but I don't even understand what the charges are.
Okay. And do you have any questions for me about any of the rights that I listed, that you have to have an attorney and have a hearing and present evidence? Do you have any questions about any of those rights?
I have a whole question about the whole context of everything today, Judge Gothier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it and say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
It's a
Now,
common
it's
law
not
thing.
about anybody's personal feelings. It's about the authority of the court to compel appearances, and you did not appear. So I do believe, based upon your answers, that you do understand the maximum penalties that you face and the rights that you have. So, Ms. Bridgman, Mr. Villanueva indicated that you wish to plead not guilty to those charges of contempt. I gather from your comments that you agree that you're not pleading guilty.
Correct.
That's correct. Okay. All right, so we'll enter a not guilty plea on your behalf to both contempt citations. We'll schedule this for a hearing where the prosecutor will present evidence, and you can present evidence in your defense. If you want to have an officer come testify on your behalf, you can certainly do so.
I would like to request a trial by jury.
There is no right to trial by jury in a contempt matter. So that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing.
I've told you what you charged. I can read it again if you want.
I don't see where there's a code or a statute or any law that I have actually violated here.
Well, that's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will.
Okay, and the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one now.
What
Okay.
one do you have?
And this is preventing, and how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva?
There's two items checkmarked here.
This is after the fact, so then you added a different charge than the previous one about the same date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me. I probably have more degrees than you do,
All right.
okay?
All right.
Now,
I'm going to find that,
please, Judge Gothier.
sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one.
Would you like to see what she has
But-
here?
I just, so you
Okay,
don't.
so how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failing to show.
But I wasn't on bond. So both show causes are not in effect because I'm not on bond.
Your Honor, what is the date of the first show cause?
December 20th.
No,
Sorry, that was before the December 20th.
Sorry. You may view this document. This is out of the court file. You may view it and then.
So- Judge Gothier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do.
Okay.
That is a hearing date. Today, we're going to schedule a hearing date, and you can present that evidence at that time.
And how will the hearing affect a trial by jury
As I told you, there is no right to trial by jury
for
in
a contempt charge?
So I
Oh,
can
so
schedule
this is a perfect, nice little tidy package for everything. I see. Okay,
So I can schedule this for a contempt hearing on Thursday, January 11th at 2 p.m.
I think that would be way too soon for me. Thank you.
Why is that?
I need to get to some of the documentation and follow up with that. state trooper, as well as perhaps a few other people, because I'm guessing, am I supposed to just talk to the prosecutor without the other witnesses that I had in my presence at the same time?
I could schedule this for the afternoon of Thursday, January 25th, then that gives you 3 weeks.
Thank you.
So we'll schedule this for a contempt hearing on both allegations of contempt on Thursday, January 25th at 2 p.m. And do I understand correctly, you do not wish me to appoint an attorney that you want to represent yourself?
And then who makes the decision? You make the total decision then?
Well, no, first you make the decision whether you want to represent yourself. As long
No.
as I'm convinced that you're doing so of your own free choice, that you understand what's going on, and that you're not going to be unduly disruptive, then you'll represent yourself.
So what am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath, yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own.
So
If you want to subpoena somebody, what you would do is you'd go to the court clerk, they give you the paperwork, you'd fill out the subpoena, they would give it to me to review, and if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena, and it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant. But everybody looked for it online at VineLeague and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all going to be sorted out at the hearing, okay? We don't have to sort all that out.
Well, that's a lot of overnight in being arrested downtown and everything for a misunderstanding that I would like to,
Mr. Richmond, I mean,
okay, I get it,
you're not
Judge Gothier, I know what happened.
You're not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
Yeah, but I brought it at 9:00 because do you know that that's actually a common law practice? And there are courts that recognize common law because sovereign people and people who take an oath of office can follow common law.
All right, so the
Not the
hearing
codes and
on both
statutes.
matters is scheduled for Thursday, January 25th at 2 p.m. I find that Ms. Richmond is unequivocally exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with the court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Richmond's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of that's a question of law that you can research before that day. And I said I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself, because an attorney, has access to and better training and researching the case law, interpreting what that is. The Michigan Supreme Court has issued some opinions about what that is. If you're representing yourself, you're going to have to find those on your own and make the argument as you see fit. If you want to hire an attorney, or if you want an appointed attorney, they would be able to fashion those arguments on your behalf. But I'm not going to.
No, I've been down that path before, and it never turns out the way they first present themselves to you, that they're going to fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your standard was going to be.
It's going to be what the law requires.
But I'm not sure which law you're referring to. So I have to research all the laws to determine what this says that is different than the first show cause.
Yeah, Ms. Richmond, if you want to represent yourself, it's a little bit more work.
I'm not saying it's not more work. It's also not presented in a way that tells me what I'm really being charged with. Or that anybody has any proof of what they said here. So that's what okay.
All right, well, that's what we'll.
All right,
sort out those
thank you.
Arguments, and the prosecutor will present witnesses at that hearing, and you can present witnesses. As I said, if you desire the court's help in compelling the appearance of any witness on your behalf,
Okay.
submit a subpoena to the clerk's office that I would review. It'd be the district court office.
Okay.
That I would review, and I would issue the subpoena.
So one of the key laws would be that in the state of Michigan, anybody practicing law should have, be a member of the Bar Association. Am I correct?
That is correct.
Yeah. Now.
Ma'am, you have to figure that out at another time, okay? Now's not time to litigate this case.
Yeah, so I have a range
I
of
get it,
charges to
but
set-
I appreciate that this is very big in scope, and Michigan statutes and codes, as he says, he's compelled to follow or must obey the dictates. Okay, I'm very well versed in enough constitutional things, so I have to know what the perception is there. So, thank you, I appreciate any clarification.
I do have to follow what the, any decisions of the Michigan Supreme Court are binding law on the lower courts. There are constitutional system in Michigan. Also, any statutes that were passed by the legislature and signed by the governor are laws that this court and all citizens of the state of Michigan have to follow.
So the procedure that was followed here, I could still take up in another manner, correct?
I'm not sure what you mean by another manner. At the hearing, you can challenge the procedure of it.
I was talking to your investigator. She knew what time I had a court date.
Yes, absolutely. If you want to present that person to come testify about that.
Oh, she's not going to come testify, I'm sure. She's downstate. She might write something.
Well, that's up to you, what you want to present. If you're going to
Okay.
represent yourself, you have to decide how you want to present your case. But I've given you the extra time you've asked for.
So this is a major judicial review, okay, to decide if anything in our Bill of Rights actually applies to the Michigan code and statutes.
You have all the rights in the Bill of Rights. I recognize all those constitutional rights.
And most of what I talked about actually falls under common law because it's common that anyone could understand it.
All right.
That's why it's called common.
Set the hearing date.
Okay.
We'll arraign you on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance or whether you should be required to post a bond before the next hearing. All right, Ms. Bridgman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether...
I showed up at 9 a.m., Your Honor, and anybody could have called me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps Supreme Court? That's the overarching question here, I think. And I think a lot of people
Well, I can
struggle with
recommend the
that.
Schoolhouse Rock video to you about how a bill becomes law and the laws.
Oh, I know how it happens.
Your Honor,
I also know we don't have a lot of judicial review.
So
Your Honor,
that's
part of
the
the-
question. Any input, Mr. Villanueva?
Yes, I guess I know you just released me as the attorney of record, but I guess in support of the bond on her behalf,
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgman is a resident of the city of Sheboygan. She advised that she's a former social studies teacher. She's presently collecting disability, so she informs me. I'm unaware of the status of if she has an automobile or anything. I'm not aware of any known criminal history for Ms. Bridgman, and she reports that there's no drug or alcohol issues. Granted, there's this allegation of not appearing at a previous hearing, and she was picked up, I believe, within the Sheboygan County for that. And so I advise that Your Honor, and one last thing, she's a politically active member in the community. She has audited an election previously. So I believe, she's more or less, I guess, committed to this area, this local municipality. It seems unlikely that she would go anywhere, and how she would do that. And so, Your Honor, I would ask that you set reasonable bond for her release.
Thank you.
All right, thank you. Well, I don't believe that Ms. Bridgman poses any danger to public safety. I don't think she's a flight risk per se of fleeing from the jurisdiction. However, I do believe that she's a heightened risk of just flat out refusing to appear, as evidenced by the fact that she cut up the previous show cause into little strips and wrote that she wasn't accepting an offer.
Well, they didn't.
It wasn't an offer, it was an order.
Sorry.
To appear.
They didn't actually hand it to me.
Just refuse to appear on orders to appear by saying, sorry, I don't want to. So I don't think that release on her own recognizance would be sufficient to secure her appearance. So I'm going to set bond in the contempt matter at $10,000 cash or surety in the full amount. There would be no special conditions attached to it, however, just the standard conditions, Ms. Bridgman, that you have to make sure that we know if you change we have to know your address, contact information. You can't violate any laws in the state of Michigan or any political subdivision thereof, and you must appear for all court appearances.
So the whole bond thing keeps me under your jurisdiction, which I wouldn't have come into your court the same way today, except that you put me in jail, so I was forced to.
That's the bond that I've set. So
This is the struggle between keeping my oath to defend the Constitution and adhering.
I've taken a similar oath, and I believe I'm going to get one today, Ms. Bridgman. So we'll see you on the 25th.
We will look at the case law.
That's what it is. All right, adjourn.
This way.
I know. She's only up here from North Carolina.